Supreme Court of India Ballu and another versus State of Madhya Pradesh decided on April 2, 2024 SEC Online SC 481 Facts of the case. The deceased Mahesh Sahu was in a love relation with Anita, who is the daughter of respondent number 2 Jamna Bai, appellant number 2 herein, and sister of Ballu Urf Bolram Urf Balmukan, appellant number 1 herein. The marriage of Anita was solemnized with another person. Even then, they were in contact with each other. Due to this enmity, on June 7, 1992 at about 11 p.m., the appellants caused death of the deceased in furtherance of their common intention after Beni Prasad Urf Bari Prasad, prosecution witness, 1, and Sumitra Bai, prosecution witness, 6, who are the father and mother of the deceased, came to know about the incident. They came to the spot of the incident FIR under sections 302, 201 and 34 of IPC was registered. Sessions judge had acquitted the appellants. High Court convicted the appellant number 1 and 2. Findings of the court: undoubtedly, the prosecution case rests on circumstantial evidence. It is settled law that the suspicion, however strong it may be, cannot take the place of proof beyond reasonable doubt. An accused cannot be convicted on the ground of suspicion, no matter how strong it is. An accused is presumed to be innocent unless proved guilty beyond a reasonable doubt. The law with regard to interference by the appellate court is very well crystallized. Unless the finding of acquittal is found to be perverse or impossible, interference with the same would not be warranted. It is not in dispute that the death of the deceased is a homicidal death, and as such, it will not be necessary to refer to the medical evidence. The only question that remains is as to whether the prosecution has proved its case beyond reasonable doubt and as to whether the appellants are guilty of committing the crime. That we have culled out from the judgment of the learned trial judge, make it clear that the learned trial judge has done a very elaborate exercise of discussing the evidence in great detail. We therefore would not like to burden our judgment with more details. The aforesaid points are more than sufficient to come to a conclusion that the prosecution has failed to prove any of the incriminating circumstances beyond reasonable doubt, and in no case, the chain of circumstances, which was so interlinked to each other that leads to no other conclusion than the guilt of the accused persons. We have no hesitation to hold that the findings of the learned trial judge are based on correct appreciation of the material placed on record. We find that the learned trial judge had given sound and cogent reasons for discarding the testimony of the investigation officer and the other witnesses. We are of the view that the High Court has totally erred in observing that the trial judge had brushed aside the evidence of the investigation officer simply on the basis of conjectures and surmises. Rather, it is the judgment of the High Court which is based on conjectures and surmises. The High Court could have interfered in the criminal appeal only if it came to the conclusion that the findings of the trial judge were either perverse or impossible. Discussed hereinbefore, no perversity or impossibility could be found in the approach adopted by the learned trial judge in any case, even if two views are possible and the trial judge found the other view to be more probable. An interference would not have been warranted by the High Court, unless the view taken by the learned trial judge was a perverse or impossible view. The judgment passed by the High Court is totally unsustainable in law. The appeal is allowed. The impugned. The High Court is quashed and set aside. The accused persons, appellants herein, are acquitted of all the charges.